When are data breach notifications legally required? Imagine waking up to find your personal information has been accessed without permission. How quickly would you want to know? That's where data breach notification laws come into play. These rules tell organizations when they have to alert people and authorities about a data breach. A data breach happens when sensitive information like names, addresses, health records, or financial details is accessed or shared without permission. It's considered a breach when this data is stolen, lost, or accidentally exposed through unauthorized access. But not every breach triggers a notification. Laws set specific thresholds to decide when a warning is needed. For example, if a breach affects 500 or more people, many laws requiring immediate notification. If fewer people are impacted, the organization might only need to notify if there's a real risk of harm. Timing is also important. Most laws specify how soon organizations must notify affected individuals and authorities after discovering a breach. For instance, some laws requiring notification within 7 calendar days if the breach involves 500 or more customers. Smaller breaches might have longer or different timeframes, but the goal is always to act quickly. Organizations must notify 3 main groups. First, the people whose data was compromised so they can protect themselves from identity theft or fraud. Second, federal or state agencies that oversee data security and privacy. For example, the Federal Trade Commission or the Department of Health and Human Services. Third, other stakeholders like investors or critical infrastructure providers, depending on the sector. Certain industries have their own rules. Healthcare providers must follow the Health Insurance Portability and Accountability Act, which requires reporting breaches of protected health information. Financial institutions must comply with the Gramm-Leach-Bliley Act, which covers customer financial data. Telecommunications companies have specific rules from the Federal Communications Commission. Organizations also need to keep records of breaches and notifications for at least 2 years. This helps with compliance and possible investigations. Sometimes law enforcement asks for delays in notification if revealing the breach could interfere with an investigation. If data is encrypted or secured with strong security measures, organizations might not need to notify at all. While all 50 states have their own breach laws, they differ in details like how many people must be affected and how quickly to notify. There is ongoing talk about creating a federal law to make these rules more uniform and easier to follow across the country. In the world of artificial intelligence and technology law, these rules are especially important. AI systems process huge amounts of personal data, which increases the chances of a breach. Companies using AI must have solid security and clear plans to detect breaches early and notify the right parties on time. As AI regulations develop, transparency about breaches involving AI data will become even more critical. In short, data breach notifications are required when sensitive data is accessed or disclosed without permission, and the breach meets specific risk or impact thresholds. Organizations need to act fast, notify the right people, and stay updated on evolving laws to keep data safe and maintain trust.